Welcome to Work This Way, a labor and employment law podcast. I'm Tina Emerson, here along with Maynard Nexsen attorney Jennie Cluverius. Our hope is that this new podcast will serve as a resource for employers, HR professionals, and business leaders while navigating the dynamic and ever-changing world of employment regulations. Each week, I'll be joined by a Maynard Nexsen labor and employment attorney to discuss insider tips and breakdowns of the newest legal guidance, while we welcome guests who are the top voices in employment law issues. For those of you who don't know this week's co-host, Jennie Cluverius, she is the go-to legal resource for some of the top employers in the Southeast and also serves as the practice group leader for Maynard Nexsen's Labor and Employment Practice Group. Jennie, thanks for joining us today.
Thank you for having me.
Of course, for our inaugural episode, we're also joined by Drew Rogers. He is a senior federal mediator for the Equal Employment Opportunity Commission, or the EEOC. Drew, thanks for being here.
Great to be here.
We are honored to have you here. Tell us a little bit about your background and how you came to be a mediator for the EEOC.
Well, I just had my 15-year federal anniversary on September 4th. So it's been a good ride with the federal feds, I guess. So, and I intend to stay as long as I can. So I started out in the military. I was on submarines, and I did that for 6 years, and then went back to school and did well there, and worked as a pro bono for the EEOC for some time, and then got hired on in Kansas City as a staff mediator, and enjoyed that. And then an opening came available in Greenville, and never even heard of Greenville. I think maybe in Forrest Gump or something like that, but never been here. And the opportunity opened itself, and my wife and I moved here, and we love it. So, but it's been great.
Wonderful. Well, we're certainly glad that you did. So we appreciate you coming on with us today. And I wanted to start off by talking with you about the charge filing process. So most employers know that most employers and most employees know that in order to prosecute a claim of discrimination against their employer, that the employee has to file a charge. And that charge is typically filed with the EEOC or with the state deferral agency. So can you talk to us just a little bit about the charge filing process and how a charging party actually initiates a charge filing?
Sure, and I think it's a good point you made there first, which is that, generally there's, either with the state agency or the EEOC, which is federal. So you have 180 days with the state agency or 300 days with the federal agency, and that can be nationwide. So that some agencies or some states don't have a state agency. Like, for instance, I think Kansas doesn't have one, but they have work share agreements, so they can just kind of swap cases. So you may see one that goes from EEOC to, SHAC, or South Carolina Human Affairs Commission. So, but when a charge gets filed, a person has to go on to the digital portal, the online portal. We are completely paperless. It used to be we mailed charges. We don't do that anymore. So they go on and they file a charge, and then it comes in, and that individual will basically file an inquiry, and that doesn't mean the charge has actually been filed or perfected. It just means they've kind of got their place in line. All right, so then they have to do an interview with one of our intake staff, and it's whoever's essentially on call. So think of it like a nurse on call, right? But with an EEOC representative. And then they get their place in line and they do an interview. And so then they will do that interview. The intake individual will tell them, based on what they've heard, whether their case will move forward, if it's, meets the prima facie setting for their case to move forward.
So the EEOC doesn't necessarily accept every single charge that is filed.
That's correct. So, and also an individual's not able to just, I think there's a fear out there that people can just file 15 charges or 10 charges and you've got all these charges out there. If someone files multiple charges and they are essentially duplicates, they'll be merged into one with one charge number. So employers don't need to be fearful that somebody can do that, because that when they get their their interview that will all be merged in. And the intake representative will tell them, hey, look, your charge doesn't meet the basic requirements of that prima facie case, or yes, it does. And now going back to the stratification, we use what's called the priority handling charge procedure, and that's a confidential method that we have within the EEOC. And I'm not, the mediation unit is not something we see or are a part of the intake, because that would jeopardize our neutrality. So we have three different sides essentially. I'll maybe talk about that in a little bit, but the priority charge handling procedure, PCHP, essentially says, okay, are these things that are priorities of the EEOC? Does it meet this? Is it meeting certain requirements, things like that? And so it can be stratified into one of certain categories, A's, B's, and C's. So C charges might be untimely. It's not within the 300 days. It might be somebody who thinks, for instance, there were a lot of housing issues when I was in Kansas City. They might say, well, I feel like I was discriminated, but it's a housing issue, so it needs to go somewhere else. Little things like that. So those cases will be essentially dismissed and then move forward. So B cases, they need more information. It doesn't meet all the criteria of, hey, it's right there, there's direct evidence, things like that. And A cases might have something a little more meat on the bone, essentially, like maybe an audio or video recording, pictures. And so those cases even have a little more clarification to them. And a lot of times the EEOC will say, well, we're seeing a cause finding potentially here because something the charging party has provided. So some of those might not be eligible for mediation. So.
Okay, and how do you know which charges are and are not? Well, how does an employer know whether their charge is eligible for mediation or not, whether the agency has classified it as eligible for mediation?
Well, you can go on to the digital portal. You definitely want to make sure, if you have representation, that you provide them with all the information, so the representative, your legal representative, can log on and get all their information in. And if need be, the investigator or the mediator or the legal individual dealing with the case from the EEOC can contact them. But the digital portal will send them updates. So, when a charge becomes perfected, when the charge has been signed by the charging party, they will get access to that charge. So you just log onto the portal and access everything you need. It's all right there, and pretty easy to use digital portal. So I found it easy to maneuver. So.
And by way of follow-up to that question, how does an employer know if they have received a charge of discrimination?
So if they've received a charge of discrimination, you'll get what's called a notice of charge, which is the email, and it says, here's, you've received essentially a charge from the EEOC. It'll have the charge or a link to log on and a unique password. You have to log on and then change the password. And then once you do that, you have access to all the information you need. You can do a position statement. If mediation becomes available, you'll get another email, or it will change in the top of the tab there. Mediation is available. You can elect yes or no, or you can ask questions like, say, hey, we need more information. But there's lots of information there for you.
And Drew, tell us about the EEOC's mediation unit. What does it do?
Sure. We have a mediation, depending on how large the area is, it's divided up into districts. So like the Charlotte district is comprised of offices in South Carolina, North Carolina, and Virginia. And we're the only office, so I'm the only mediator essentially in South Carolina. We have a few offices in North Carolina. It's a larger region. And in Virginia, we have 2 offices. And then I think as a whole, there's just right around 100 mediators in the U.S. And then we have ADR coordinators, or the supervisor essentially, and they then control or have control of those districts. And then there's one head of the ADR unit, and he's in DC. So we're really, if you're getting a staff mediator, you're getting really a well-trained individual. And then we have pro bonos, and then we have contractors, and they get contracts every 5 years, so they can operate, within the district, or they can have other districts as well.
Why would you propose that parties consider mediation, both the respondent and the charging party? What are the benefits of mediation? Why is it something they should weigh as an option?
Our program is truly unique in that it's cost-free, okay, and you're getting well-trained mediators. All right, these are individuals who have done it either for a very long time, or many of them were previous investigators, so they know the law, they know how things work. Not every person is an attorney, so they're bringing different skill sets in, and the average success rate hovers right around 70%, which is very high. So you have to understand that you have a very good chance by coming in, and there's no cost. So for a charging party or a plaintiff, if they're pro se, there's no cost to them. If they're represented by a plaintiff's attorney, there's no cost like a private mediator would be, which later on, as the costs grow, you're going to have to pay for a private mediator. Like here in South Carolina, usually the courts will mandate you go back to mediation. So there's additional fees that go into it. For a respondent, again, the same thing, no cost, but you're getting an experienced mediator who usually is bringing quality mediation to the table. So the unfortunate part about that is there can be a wait time to it. So
and what happens with the charge during the wait time? Does it kind of sit on ice while the parties wait for their day to mediate, or does the respondent generally have to submit a position statement in the interim? How does that work?
Well, I'm glad you brought that up, because that is another added benefit for the respondent. If you choose to mediate, you do not have to do a position statement. It gets placed on hold. So that is an added cost benefit for the respondent or the company. And so general costs can range from $400 to $7,500 for a position statement, or if you get someone really good like you, right, you $25,000, right? So
I don't know about that.
No, I'm just kidding.
Well, is the mediation piece, is that confidential? Does the EEOC mediation side communicate with the investigation side?
So I think there's a misnomer out there that because we all office in the same place, right, we just walk on down and lean, hey, what's up with that case or whatever. The reality is it's 100% confidential. We do not communicate the results. We don't communicate case files. Even in our filing system, like our digital system, enforcement and legal, they can't even access our notes. They can't see the results of the outcome of our mediations. Only mediation can see mediation, and it's not like a cross vice versa thing. So there's no need to fear that whatever occurs in any settlement document you sign, because we do have an EEOC mediation agreement, and it's very basic, and we allow you to do a general release, so you can have your own separate agreement. But what you sign for us, it never gets released to the public. And so there's another benefit for a company to come in and do that. You can have a separate release that we don't need to see, we don't need to be a part of. It's
and of course, we're at the charge filing stage, so there's usually not litigation that's already been filed against the respondent. Mm-hmm. So that's potentially another added benefit of engaging in the mediation process early.
Yeah, there's no public component there's no public visibility to it. And essentially no one knows it occurred, mm-hmm. unless someone breaks the confidentiality provision.
So the EEOC's press releases that we see come through our inboxes frequently about settlements obtained and that type of thing, those don't relate to confidential mediations that are being held by the agency.
Those
correct?
would be separate components, like a conciliation. No, maybe I wouldn't go so far as to say a conciliation, but more like a large-scale litigation where the company, they looked at it and said, hey, there are a large amount of individuals being affected, and they entered into an agreement, and that was part of it, was becoming a public.
But your general employer respondent run-of-the-mill mediation is not going to be something that's published.
No, it's not.
Okay.
So there are clearly a lot of topics that we have to talk to you about. So we have decided, and we have enlisted you to come back and for another podcast on Work This Way. So we hope that you'll join us again. We've got a lot to discuss. So Drew will be back. Thank you so much for being with us today. We really appreciate it.
That was my pleasure.
And we will see you next time with Drew on Work This Way.